So if you check the date, right, 4/28/2025. So this was yesterday, all right? The court has read and considered the stipulation regarding requests for one, continuance of trial date, and two, findings of excludable time periods pursuant to Speedy Trial Act filed by the parties in this matter on April 25th, 2025. The court hereby finds that the stipulation, which this court incorporates by reference into this order, demonstrates facts that support a continuance of the trial date in this matter, and provides good cause for a finding of excludable time pursuant to the Speedy Trial Act, 18 U.S.C. 3161. The court further finds that the ends of justice served by the continuance outweigh the best interests of the public and defendant in a speedy trial. Failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. And three, failure to grant the continuance would unreasonably deny defendant continuity of counsel, and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. The court, having considered the parties' stipulation, docket 24, and finding good cause therefore, hereby orders as follows. The trial in this matter is continued from May 13, 2025 to October 14, 2025 at 8:15 a.m. The pretrial conference hearing is continued to October 3rd, 2025 at 10:30 a.m. The time period of April 25th, 2025 to October 14th, 2025 inconclusive is excluded in computing the time within which the trial must commence pursuant to 18 U.S.C. 3161 H7A, H7B, I, and B. What is that, 4? Yeah. Nothing in this order shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods are excluded from the period within the trial must commence. Moreover, the same provisions and or other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period within which trial must commence. Is so ordered, dated April 28, 2025. Fernando Rocha, because I cannot say the last one. But how did this happen? How did it happen? How did Bricc pull off a continuance? There's going to be some people without knowing the paperwork will say, oh man, he's getting ready to testify on Big U, or oh, he's getting ready to snitch, or whatever the case may be. I tell you to hold off on that because it's real simple. But you know what? We'll just do the paperwork like we normally do because that's what we do around here. Hit the like button like you like something. Let's go. So here's the original document that got filed. Plaintiff, United States of America, buying through its counsel record, the United States Attorney for the Central District of California and the Assistant United States Attorneys, Kevin, Jenna, and the defendant, Zaire Mitchell, both individually, and buying through its counsel of record, Megan Elizabeth Foster, hereby stipulate as follows. The indictment in this case was filed on February 26, 2025. Defendant first appeared before a judicial officer of the court in which the charges in this case were pending on March 19, 2025. The Speedy Trial Act, 18 U.S.C. 3161, originally required that the trial commence on or before May 28, 2025. On March 19, 2025, the court set a trial date of May 13, 2025, and a status conference date of May 2nd, 2025. Defendant is detained pending trial. The parties estimate that the trial in the matter will last approximately 2 to 3 days. By this stipulation, defendant moves to continue the trial date to October 14, 2025, and the status conference date to October 3rd, 2025. This is the first request for a continuance. Defendant requests the continuance based upon the following facts, not speculation, facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. Defendant is charged with violations of 18 U.S.C. We're just going to say what it is. We ain't going to go through the numbers, but felon in possession of firearms and ammunition. The government has produced over 5 gigabytes of discovery to the defense, including law enforcement reports, search warrants, and returns, criminal history documents, recordings, and photographs. The government is in the process of producing voluminous wiretap recordings to the defense as well. Defense counsel is presently scheduled to be in the below described trial, as well as various sentencing hearings in the other matters, including on May 5th, 2025 at 9 a.m. for Alejandro Sanchez. May 16th, 2025 at 9 a.m. I don't know how to say any of this, but whoever that is, RICO case regarding the Anom enterprise involving FBI interception of criminal communications globally. This will be a highly contested sentencing and would directly conflict with defendant's current trial date, May 16, 2025 at 10 a.m. for Andre Cardozoles. Okay. Drug importation, June 6, 2025 at 9 a.m. for Cynthia Margot Rosas Rodriguez. Okay, June 6, 2025. So basically, whoever going to come in for drug importation, money laundering, international wire fraud, money laundering. God dang, okay. What else we got? Been putting in their sentencing for about 18 months. Waiting for completion of drug court. Accordingly, counsel represents that she will not have the time. Also, she's basically saying that my other people that I have, I'm not going to be able to do this. And there's a reason for that, because Bricc has a public defender right now. So accordingly, counsel represents that she will not have time that she believes is necessary to prepare and be available to try this case on the current trial date. All right. So basically, she starts showing all the individuals that she's representing. And there you go right here. Continuance is likely to be given. She basically went through all the reasons why. So if y'all care about that, she's just saying she got a trial scheduled for July 15th, and then the length of that is about a month. Then saying the continuance has been granted so far. Counsel personally is not ready to proceed on the current date, and several other defense attorneys will not be ready on the date, especially if circumstances change with regard to charges / penalties. The continuance is very likely to be given. The number of defendants remaining. So yeah, it is likely that this trial will proceed on scheduled date. I mean, it's not likely, sorry. So, in the light of foregoing, counsel for defendant also represents that additional time is necessary to confer with defendant, conduct and complete an independent investigation of the case, conduct and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in this case, and prepare for trial. In the event that a pretrial resolution does not occur, defense counsel represents that failure to grant the continuance would deny her reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Defendant believes that failure to grant the continuance will deny him continuity of counsel and adequate representation. The government does not object to the continuance. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorney for the government, or the defense, or failure on the part of the attorney for the government to obtain available witnesses. For purposes of computing the date under the Speedy Trial Act by which defendant trial must commence, the parties agreed that the time period of May 13, 2025 to October 14, 2025 inclusive should be excluded pursuant to 18 U.S.C. 3161 H7A. And they keep going through with those. Because the delay results from a continuance granted by the court at defendant's request without government objection on the basis of the court's finding that one, the ends of justice served by the continuance outweigh the best interests of the public and defendant in a speedy trial. Failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. And failure to grant the continuance would be unreasonably deny defendant continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Nothing in this stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate the additional time periods to be excluded from the period within which trial must commence. Moreover, the same provision and or other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period within which trial must commence. It is stipulated, dated April 16, 2025. I am Zaire Mitchell's attorney. I carefully discussed every part of the stipulation and the continuance of the trial date with my client. I fully informed my client of his speedy trial rights. To my knowledge, my client understands those rights and agrees to waive them. I believe that my client's decision to give up the right to be brought to trial earlier than October 14, 2025 is an informed and voluntary one. And then boom, you got her signature, Megan Elizabeth Foster, attorney for defendant Zaire Mitchell, and then basically he signed at the bottom. So I want y'all to pay attention right here. Designation, CJA appointment right here. All right. So y'all see that? All right, cool. So we're gonna get rid of that. Jump over. So here you go. What is CJA appointment attorney mean in a federal criminal case? A CJA appointment attorney in a federal criminal case refers to an attorney appointed under the Criminal Justice Act, CJA, to represent a defendant who cannot afford to hire private counsel. Here's the breakdown. CJA, Criminal Justice Act of 1964. This federal law ensures that individuals charged with federal crimes receive a competent legal representation. So there y'all go, bro. Ain't finna do too much.
Now, as far as the ranking system go, I'm just being fair, square, obvious, and honest, right? As far as the ranking system goes, remember, Bricc is facing 15 years. Please note and know, I ain't changed my ranking system. As far as people who have a chance to beat their case in the feds, Loose Cannon here, Bricc right here, Big U here. Meaning easiest, medium, hardest. I'm just going to be fair, square, obvious, and honest. Now, let's kind of delve into what Bricc is accused of doing. Brick's whole cases is all about essentially having firearms. And it's crazy because once upon a time, having firearms used to be a misdemeanor crime. Look it up if you don't want to believe me. But with the government and laws and certain things, and we can get into colors and racism and all these dated laws and stuff like that, it's been enhanced to a felony. Now, that doesn't mean that the felony doesn't preclude anybody. It includes everybody. So there's that. But to go even further, Bricc will have to climb a mountain that pretty much, I don't know the strategy here. Not saying that he's guilty of everything, because there's certain things that I'm fairly certain he's not guilty of. His baby mama definitely needs to leave, or they need to hurry up and get married or something like that, so that way she can't show up to court. Because if she goes and she has to testify and all of these things, her story may be strong, but the questions, they're trying to catch you up, they're trying to trick you. That stuff right there that the feds can do, that attorney that sits there and prosecutes cases for the federal government in the name of California, they're good at their jobs. They didn't get to where they got to by happenstance. Nah, they got there for the right reasons. So it's going to be interesting to see, because she will be a witness on that stand. Now, other people may be like, well, she can get up there and she can basically exonerate him. All right, cool. He still has the other gun charges that he has to beat. So what essentially Bricc, I'm assuming he's hoping for, I ain't spoke to Bricc since he's been locked up. What I'm assuming that he's hoping for is a lot of these charges basically fall off and he gets X amount of time. But the way that the feds are set up, he's going to need his lawyers to essentially try to figure out what type of point reductions that he can get. It happened in the Big Meech case. So I don't want to hear y'all talk about anything of, oh, Big Meech is a snitch. No, this right here, whether you believe Big Meech is a snitch or not, Big Meech getting his points knocked off is due to pure lawyer work. So we'll see how he can get some points shaved off and it can basically bring it down, because that's what he's going to need. Is Bricc going to beat his charges flat out? I don't know. Now, he can always run the whole, hey, man, that wasn't my gun. That was in the car. Everybody drives that car. That's the Golden versus California. Golden versus the feds, basically. That's that one right there. So if he can pull that one off and use NBA Youngboy's defense, then good. Then he has a chance. But the other problem that he has is the initial siren that got the feds and the police on him. When they said they had camera footage, basically, of him shooting in self-defense, which is insane. They said that Bricc was about to get robbed and basically said, I ain't going, and started shooting. Anywhere else, if he wasn't a felon, they'd give him a medal. But this is the streets. So it is what it is. They're saying he wasn't supposed to have a gun anyways. They still got to prove it was him. So Bricc has a very difficult case to beat. But if you're talking strategy, Hey, them guns that you found in the house, those wasn't even mine. Just gonna say that. Now, the feds can say, well, then, you know what? If they weren't yours, then whose were they? I mean, could be somebody else's. There are rumors of other things going on in that house. Could be a setup. Who knows? But either way it goes, is it beatable? From what I just laid out, that's pretty much it. That's all he has. In my opinion, y'all can come up with other theories, or y'all can say, nah, bro, he hard-boiled egg cooked. You can say that, and it just is what it is. But shout out to his lawyer for getting the continuance, because bro would have walked in there and got smacked with a baseball bat in the back of his head. Just gonna be honest with y'all. But hey, man, hit that like button like you like something, subscribe, turn on the bell, stay notified, and I'll catch you on the next video. Go ahead and click right there to see Lil Durk respond to the feds. And to the other dude that's dissing, I won't be responding to you. I'm sorry. But enjoy your day.